Sorry, all. Part two here. So welcome again, and welcome to the first in our three-part series, Do You Have a Plan? How to Avoid Leaving a Mess. This is going to be presented by Tiffany O'Connell. My name is Ryan Anderson. I'm the Outreach Manager for Kendal at Home. And with us today from the Kendal at Home team is Lynn Giacobbe, our CEO, as well as Sue Woykin, Marketing and Events Coordinator. And Sue will be monitoring the Zoom for any technical issues going on, as well as looking at the Q&A and chat for any questions and comments, concerns that come up throughout. Before I introduce Tiffany here, just some three housekeeping items. One, the Q&A and chat. Please feel free to type that throughout if you have questions that you want addressed. Tiffany would be more than happy to answer those at the end of the program, or we might interject and bring them up throughout the program as well. So please feel free to type that at any time. If you would like to change the view format on it as well, in the top right-hand corner, you can do so there to change how the presentation is being presented with the PowerPoint, as well as the new feature here we're trying today, closed captioning and live transcript. So at the very, very bottom, if you click on that, the first option that pops up is to show or hide the subtitles if you would like to use subtitles or if you would like to turn those off. As well as the third option there is going to be a settings feature where if you click on that, it will bring up a slide bar where you can either increase or decrease the size of the subtitles depending on your preference there. So without further ado, Tiffany O'Connell is with us today. Tiffany is the principal out in O'Connell Law out in Natick, Massachusetts, focusing on estate planning, trust, probate administration, wealth strategies, retirement strategies, among other specialties. Tiffany, thank you for joining us today, and we're really looking forward to hearing your program today about, I believe it's key documents in estate planning and really looking at, is a trust the right way? How do we prepare and so forth? So thank you so much.
Great. Well, thank you very much for inviting me to come speak. And I am absolutely thrilled to see the great turnout for this. Who knew that people would want to come and hear about death and disability? But I say that tongue in cheek, but it's so important. So I'm going to actually share my PowerPoint presentation as I talk. The PowerPoint presentation that I'm going to share is more just to kind of have a visual. So it's not going to have a lot of content in it. So please, I know that Ryan would have sent you beforehand an assessment worksheet that can go along with this. And I actually want you using it. If you didn't get it, please, because I'm in the chat, so that way Ryan can help get that for you, but the worksheet's really going to help you as we go forward. As Ryan said, this is a three-part series, so you're going to get to see me 2 more times. So that being the case, today we're really going to just be focusing on the actual documents. So just know that I know probably a lot of questions will pop up for you all as we're going through this, but we're really going to compartmentalize so that way we can really help guide you through this. So with that, I'm going to go ahead and share my screen and actually start the PowerPoint. So just bear with me a second. Sorry about that. And Ryan, if you can just give me a heads up that everyone's seeing this PowerPoint.
Yep, we can see it.
Okay, wonderful. So thank you. So, all right. So a couple of things just to note as we get started. First of all, again, I want you filling out that worksheet as we go along, because it's just going to help you for your own planning as you go forward. Now, being an attorney, I actually do need to go over a few disclaimers with you to make sure that you guys understand this is not legal advice. This is not a how-to for doing estate planning, nor is my book, right? The devil is always in the details. So always, I want you seeking professional guidance and meeting with an estate planning attorney when doing your estate planning. Now, I know I've got folks from all different states here too. So it's important that you actually meet with someone who is licensed in your particular state. Even though those disclaimers, I really do believe this workshop is worth your time. My goal here is really to help you understand estate planning and what you should be thinking about. So with that, let's get started. So what is estate planning? You kind of hear that term out there. So I really believe in bringing things down to a very basic level, just because you don't need all the legalese. Now, I'm going to be talking about a lot of legalese as we go through this, but just know that it can be as simple as saying, look, estate planning, it's just putting a plan in place that says what you want to have happen if you can't take care of things. What a lot of people are surprised at is that it applies not just upon someone passing, but estate planning is just as important, if not potentially more important, to be able to cover if you should ever become incapacitated. When I'm talking about incapacity, I'm not talking about a broken leg incapacity. I'm talking about something that keeps you from handling your financial matters. So for estate planning, that actually applies for both upon passing as well as if you can't take care of things. So I hope that makes sense. Now, on your worksheet, you're actually going to go to the first part of it, which talks about what is estate planning. So I actually want you taking the moment and actually filling out on the worksheet. It's going to ask you, if you did estate planning, have you, 1, never done it? 2, was it over 5 years ago? C, which is 3, was it within the last 1 to 5 years? Or D, I just did it. So yay me. So I would like you to fill out what is the most appropriate for you. Now know that after this workshop, I'm actually going to be sending you my answer key for what I think you should be thinking about based on what you've chosen. But please go ahead and mark that now. So estate planning, it can include a bunch of tax planning when needed. It can provide for a way, if you have young children, to make sure there's someone who's there to take care of that child, both for taking care of the child as well as monetarily taking care of the child. It deals with how your assets, how they should be handled, and who should handle them. And we're going to have a whole separate workshop talking about the who. Now, when I'm talking about who should help for taking care of kids or taking care of assets, you're going to hear me say oftentimes helpers, because really that's what they are. They're helpers. They're either taking care of things on the financial end for you, or they're taking care of kids, or they're making health decisions for you, but they're all helpers. And then tying with the health decisions, an estate plan, it deals with who's going to make those medical decisions for you if you can't make them yourself. So knowing that, we're going to actually break this workshop into 2 components. The first part that I'm going to talk about is what happens if you're not living. And then the last part that we're going to touch on is, okay, you're living, but you're incapacitated. So just know when I'm talking about the documents, I am going to break it apart into those 2 categories. So the first one is, what happens if upon my passing, what happens? So the first concept that I want you all to get is what probate is. And there's probate in all the different states. So I'm going to speak generally because probate can run a little differently from state to state, but bottom line is it's the same premise. The idea is that upon someone passing, it is the court process that someone goes through upon passing. And now pay attention to this part. If the person had an asset in their own name. That is the crucial part. If they had an asset in their own name. If something was jointly owned and it's said to go to a surviving joint owner, it doesn't go through the court process. If something is not jointly owned, but it has a beneficiary, so think an investment account or a bank account or life insurance, retirement account, if it has a beneficiary, it goes to the beneficiary. It doesn't go through probate. If something is owned by a trust, and we are going to focus on trusts as part of this discussion today, then it's owned by the trust and it doesn't go through probate. So why am I taking so much time to really focus on this? Because what a lot of people don't realize is the probate court or the probate process is an elective process. You can avoid going through this process if you make sure things are titled correctly. And again, titled correctly should be part of the discussion with your estate planning attorney and other professionals to make sure it's titled right for your circumstances. But by avoiding probate, guess what? You can avoid the expensive filing fees and the publication fees and all the attorney fees, all the extra fees and costs that happen when something has to go through the probate court. I don't know how other states are, but I can speak about Massachusetts. Going through probate in Massachusetts, it takes a while. So it delays someone being able to get access to something. And that could be really crucial at a really crucial time for someone because they have to wait for the court to approve them being able to handle it. And it's time consuming. And so the idea is if it has to go through the court system, you're at the time schedule of the court. You're not at your own time schedule anymore. So I really like folks to avoid going through probate if they possibly can. So before we continue on, I want you again to look at your worksheet. The next part, section 2, talks about what probate is. And I want you thinking about what assets do you currently have, whether it's a bank accounts or investment accounts, retirement accounts, real property, life insurance. Is there anything that is just in your name alone without one of those categories? Beneficiary, owned by a trust, or so on. So I want you thinking about that. I'm going to just give you just a minute to think about that. And then I want you marking off either yay, A for yeah, or B for no, or you know what? I don't know. And actually, you wouldn't be surprised. A lot of people don't know. So one of your homework assignments, to the extent that you don't know, is to go and check to see how things are titled. So I'm just going to give you just a moment now, just so that you can think about it and then just mark that off. So I know I didn't give you much time. So if you didn't get to answer, just know I want you doing that after this workshop, thinking about it. But just to make sure we can get all the content in, I am going to continue on. So now the next thing I'm going to talk about is what can actually make probate easier. Something does have to go through probate. How can we make it easier? And that is by having a will. And I actually want to stop there because this surprises a lot of people because I get all the time, Tiff, no. I've done a will, and we'll talk about what a will is, but I've done a will, so I don't need to go through the probate process. I don't need to go through the court because I did a will. It says who's going to take care of things, where things should go, so I don't need to go through probate. But what a lot of people don't realize is that a will, very important to have, great to have, and it makes it easier to go through probate, but it doesn't avoid probate. It is just instructions for things going through probate. So I want that to sink in. So a will, very important, but it does not avoid probate. Again, titling, how something is titled, that dictates whether it avoids probate or not. So with that, let's talk about how it works for the will. First of all, you're going to have someone who's going to take care of things under the will and who's going to actually, at the direction of the probate court, do things. So they're the ones who report to the probate court and they're doing what the probate court wants. Now, depending on the state that you're in, that person could be called a personal representative, or it may be called an executor. It means the same thing as the person in charge that's named in the will who would actually administer what's going through the probate process at the direction of the probate court. A will would typically name who's going to inherit, who's going to receive things. Now, I just want to stop there because there is a concept called intestacy. Intestacy means that someone passed, there was something in their name alone, and they did not have a will. So every state, a lot of people don't realize this, every state has provided someone with their own estate plan. It's the same for everyone, as the default is called intestacy, and states vary as to how this goes. But the state will say where things would go. Now, it is generally going to follow bloodline, but depending on the state that you're in, it may go in a very unexpected manner. So if someone didn't have a will, and it can only speak for Massachusetts, if someone was married, but they had children from another relationship, and they had wanted to make sure that the surviving spouse benefited before any kids did, intestacy in Massachusetts would be very surprising for that person, because it turns out, at least in Massachusetts, upon that person passing, for anything going through probate without a will that dictates where things should go, things are split between the surviving spouse and the children from the other relationship. That may or may not be what that person wanted. So no one should really rely on intestacy, but it is a default backup that the state has provided as to where things would go. So the state has taken the guess for you as to where they think you would want it to go. So a will, that's where you can say where you want it to go. And so that overrides anything that the default intestacy laws would say. So a will should very specifically say where you want things to go. That is also the place where, if you have minor children, that is the place where you would nominate who you want to take care of those children. So that's another important component to a will. And as I was implying, it gets rid of the guesswork because it says what you want to have happen. So before I dive into trust, on your worksheet, you will see under item 3, under what is a will, it will ask, do you have a will, yes or no? So I want you marking off yes or no, depending on what your circumstances. So now with that, we're going to dive into trust. And I hope everyone is okay. I can't see anyone, so I'm hoping that everyone is doing fine with this information. And I know this is being recorded, and you'll also have my book to be able to reference. All right, so let's go ahead and talk about trust. So before we dive in to this particular slide, I just want to talk about what a trust is and the different types of trusts. So a trust is just a set of instructions that says what you want to have happen with anything that the trust owns. The trust can own a bunch of different things. It can own real property, it can own accounts, it can own tangible items, it can own business interests, it can own a whole bunch of different things. It can also be the beneficiary of accounts as well. It really just depends on what the purpose is and what type of account it is as to how it's going to be titled. Now, knowing that, there are 2 kinds of trusts. There are revocable trusts with an R, and there are irrevocable trusts with an I. They have very different purposes. And again, this is really detailed in the book, so this will be a really good reference for you after this. So I'm going to just touch on what revocable trusts are and what irrevocable trusts are and why you'd want to consider doing them. So for revocable trusts with the R, it's revocable. So now any of our clients doing revocable trust, I certainly don't want them revoking it because it's completely undoing the planning they did. But the idea behind a revocable trust is the person who sets it up. They can have different names: trust maker, trustor, settler, all the terms are in the book. But the person who sets it up with a revocable trust, they keep full control over it during their lifetime. So as long as they're living, as long as they have capacity, they can change whatever the terms are. So whatever the trust says, they can change whatever that says. They can also change and have control over whatever the assets are that the trust owns. So if I have a revocable trust and I put my house in it, I still have control over that. Even though it's owned by the revocable trust, I still have control. Now, the person who actually follows whatever the instructions are in a trust and takes care of whatever the assets are that the trust owns is someone called a trustee. Now, the typical thing when someone has a revocable trust is, again, as long as they're well, they're usually the trustee. They may have a co-trustee with them, but they're normally the trustee. And they are normally, during their lifetime, the beneficiary, the one who benefits from whatever the trust owns. So we have the person who sets it up, the trust maker or the settlor, or the trustor. We've got the person who takes care of things, the trustee, and we have the person who benefits, or the entity that benefits, the beneficiary. So knowing that terminology with a revocable trust, if I set one up, I'm usually the trustee, I'm usually the beneficiary. So that way I keep full control and I can continue to enjoy whatever assets I put in that trust. It's just a way to hold that for me. Now, with a revocable trust, it will normally use your social security number on it during your lifetime. So for income tax purposes, it's just filing your regular income tax return. It only requires a different tax ID and different tax return upon your passing. So, but during your life, it's your social security number and your normal tax return. So knowing that, we're going to talk about why people would do that in just a minute, but I want to touch on irrevocable trusts, the ones with the I. Hence the term. Irrevocable trusts, once they're set up, are irrevocable. Think of it as a one and done. People will usually do irrevocable trusts in order to help reduce for taxes or to do some asset protection. They're trying to get rid of an asset. Now, there are all different kinds of irrevocable trusts. There are irrevocable life insurance trusts, and there are grantor retained annuity trusts, and there are charitable remainder or charitable lead trusts. There's a whole slew of different type of irrevocable trusts. And if you ever have trouble sleeping, I recommend that at the back of the book, you actually go to the glossary, and there's a whole slew of them so that you can find out all the different types there are. So I just wanted you to realize there are two different kinds of trusts with very different purposes. Now, that said, they generally will have certain commonalities, which this slide actually goes over. So, as I had mentioned when I talked about probate, if something is owned by a trust, whether it's a revocable trust or an irrevocable trust, upon your passing, it doesn't have to go through probate. So it is a way to avoid probate by having a trust. You just have to make sure the assets are aligned with it. Another part to having a trust is because it doesn't have to go through probate, it keeps things private. So if having privacy regarding what you want to have happen is important to you, then trust can be very helpful. Now, I'll tell you, just as a little bit of an aside, when someone has specifically, usually a revocable trust, everyone still needs a will. But in that case, with a revocable trust, since we normally want everything running through that revocable trust, we have a special kind of will in case something ends up going through probate, which is called a pour over will. So the idea behind this is, oops, if I forgot that I had a bank account out there that was just in my name alone, but I had a revocable trust and I wanted everything going through there, what would happen is upon my passing, that bank account, my bad, needs to go through the probate court. But you know what? I am providing specific instructions to the probate court because I have a will. And my will says that the only beneficiary under the will is my revocable trust. So for people who can go to the court and find out what's going on, all they'll know is I have a trust. They won't know what the trust says. So I'd like to avoid probate. So I want to make sure I've got that account aligned with my trust. But just know that at the very worst, the only thing someone would know is that you had a trust. They won't know what the trust says. And that's, again, if it's a separate trust that you're creating. Because one thing I want you to note, and I know your heads are going to be spinning after this session, so just bear with me, that it is possible to actually have a trust created under a will. That is called a testamentary trust, and is actually, again, talked about in the book. But with the testamentary trust, because it's created in the will, it means that it only deals with things that go through probate. And then the testamentary trust is created for things after it's gone through probate. That's completely separate. And that's something that the will would actually create. It's beyond the scope of this workshop to say why you'd want to create a testamentary trust in a will. It's not my preferred default way to do things. I do think having a revocable trust that's separate is generally the way to go, but there will be certain circumstances where testamentary trust may make sense. Specifically, if someone is worried about going into a nursing home for Medicaid purposes, a testamentary trust under a will may be an appropriate tool. So I don't want you coming away from this and saying, oh, you should never have a testamentary trust under a will, because there will be certain times when that does make sense. And again, this comes back to devil's in the details. So it's important for you to sit with an estate planning attorney to make sure you're doing what makes sense for you. So knowing that, and knowing that one of the goals for trusts that are not this testamentary trust, I'm not going to talk about that any longer here, but for revocable trusts or irrevocable trusts, to extend something subtle, can avoid probate, and it can help keep privacy. So now we get to have a discussion on taxes. So you all are probably very well aware of something called the income tax. You pay it every year. There's also something called an estate tax or an inheritance tax. That's a tax that hits upon someone passing. Now, there is a federal estate tax. Currently, that threshold for 2022 numbers for the recording purposes is over $12 million. But there could be, depending on what state you are in, there could be a state level estate tax or inheritance tax. For example, in Massachusetts, Massachusetts has its own estate tax, and that one hits when someone's assets go above 1 million. That's much different from the 12 plus million that the federal hits. Now, people know about the federal because when it hits hard and it receives a lot of publicity. But for most people, a federal estate tax will not hit, but depending on where you are, it could. If you're in a state that has a state tax or an inheritance tax, that is usually the more common situation where people are doing planning for trust. But again, if your assets are well above 12 million, and mind you, those laws can change. That's currently what it is. And you probably have heard rumblings saying that the current administration wants to change what the estate tax is. And look, it just happens depending on what administration comes in. So the federal amount will change based on time, based on who's in Congress. And could it potentially go away? It potentially could, but then you wait for another administration, it could be back. So the estate tax will change over time, but it's currently at the 12 plus million. So knowing that, I just want to focus more on the state level because I think that's going to impact most of the people here to the extent they have a state level estate tax. So again, I'm going to speak for Massachusetts. For Massachusetts purposes, When someone adds in the equity of their home and retirement accounts and life insurance they have, it's not unusual, especially for someone in Massachusetts, to be above that $1 million mark. So if someone's goal, and this depends on what someone's goal is, but if someone's goal is, hey, I would like to maximize what goes to my beneficiaries, whether it's to my kids or whoever it might be, and I'd like to pay the minimum tax possible for that, then using specifically revocable trusts, if someone is married, can help reduce the impact for that tax. Now, I have a feeling we should do a whole workshop just on tax. So this is just kind of a quick overview of it. But that said, revocable trust, if someone's married, can help reduce an estate tax on the federal side. And then if they have a state level, if they're not married, they might be looking at irrevocable trust to help reduce that. And if they're married, they might be looking at revocable trust and irrevocable trust to help reduce that impact. One final tax I just want to mention, just so you're aware of it, is something called a gift tax. And again, there's sections on this in the book. So please, if it's like, oh my gosh, Tiff, what are you talking about? Just know in the book, there are summaries of this. So, but there's something called a gift tax. And that's a tax that hits when someone gives something away. Now there is a federal gift tax. And right now that mirrors what the federal estate tax threshold number is, so over 12 million. And depending on the state that you are in, there may be a gift tax at the state level. I know for Massachusetts there is not, but I cannot speak for other states. So when you're doing gifting, you want to be very careful though. And this is the thing I kind of want you to take away from this, because a lot of people are like, oh yeah, I'll gift. When you're gifting, you need to be very careful. And again, this comes back to the professional person who's helping you, both for the estate planning attorney, and hopefully you've got a CPA or financial advisor who's also guiding you. You want to be careful of the type of asset you gift. Now, I never want someone to gift and always let taxes drive what they're doing, but you need to be aware of how taxes hit. And so if I happen to have a Monet hanging on my wall, which I do not, but if I happen to have a Monet, and let's say that it was, I don't know, found at some little shop and I bought it for $10,000. Well, we probably all realize a Monet would be more than $10,000, right? But hey, great, I bought it for $10,000. Now though, if I gave it away, and so I'm going to pick on Ryan because I can see his name here. So if I gave it to Ryan, he takes it at what I bought it at. So I give the Monet to Ryan, and I do need to do a gift tax return to report the gift. Hopefully that amount was not over $12 million. If it was, I'm going to owe a gift tax on the federal side. And again, depending where I am, I may owe it on the state side, but I gave it to him. So under current law, he receives it at what is called cost basis. That means if I bought it for 10,000, let's say that Monet is worth 10 million. And then he decides, you know what, I don't like this Monet and I'm going to actually sell it to Susan. So he sells it to Susan for the fair market value. And then he's like, great. Well, he stepped into my shoes at $10,000. He sold it for 10 million. He's going to pay a capital gain tax on the difference. Ouch. Still a good deal, something he didn't have before, but he's going to pay a hefty capital gain tax. Now, if instead I held on to that Monet during my life, and as part of my estate plan upon my passing, it goes to Ryan upon my passing, at least under current law 2022, beginning of 2022, in case there's tax law changes, under February of 2022 law, Ryan would get what's called a step up in basis for capital gain tax purposes. And if he again sold it to Susan for fair market value for 10 million, he would not owe any capital gain tax. So this is part I want you to remember. It's crucial that if you're planning on making any sizable gifts, that you talk to a professional so they can talk with you about the capital gain impact. Because sometimes it's better to hold on to an asset during life so that someone can get the step up again based on February 2022 current law. All right, so that was just a very quick overview of taxes, but it's so important for you to understand that because that is one of the ways that trust can be used to help minimize taxes. So I just wanted to take some time there. So now, another benefit to a trust, whether it's for a revocable trust or an irrevocable trust, is you, the person setting it up, get to determine whenever your beneficiary gets control. So if someone is too young, yeah, you certainly need it until they at least get to age 18. But then you may say, you know what, age 18, that might still be a little young for whatever's going to them. I'd rather that they be age 25 before they get control, or age 30, or never. Now, never, there are certain circumstances where it needs to be never, but you don't want to do that willy-nilly. But that said, there are certain circumstances where a beneficiary should never have control. Now, the fact that a beneficiary doesn't have control doesn't mean that the person taking care of whatever the assets are and following the instructions in the trust, the trustee at that time, doesn't mean they can't be making distributions out for that beneficiary. It just means that the beneficiary themselves doesn't have the ability to use it. So we always use the example, and my illustrator, Joy, who did this illustration for the book, I love that she picked a dump truck, but I always use the example of the beneficiary who decides they want to buy the Ferrari instead of going to college, right? And so only you can decide what's right for you and for your beneficiaries. But that said, I think you get the picture. So another reason people will do trusts, and again, this could be revocable or irrevocable, is to provide for some creditor protection. Now, if it's a revocable trust that you've set up, that is not asset protection for you at all. You better make sure you have proper homeowner insurance, auto insurance, an umbrella policy. If you have a business, make sure you get the proper insurance in place. If you have an irrevocable trust, that may be providing you with asset protection, because if you just have a right to like income from that, then that's protecting the principal if it's set up appropriately. With a revocable trust, though, even though it doesn't provide you with asset protection, if you have it stay in trust for the beneficiary, even though they can have some control at some point, it can provide them with some creditor protection. So that can be a nice benefit to a trust. And we always say creditors and predators, lawsuits, bankruptcies, divorces. So if you want to try to protect for your beneficiary from those, having it stay in trust for them can help accomplish that. The final thing that I'm just going to talk about in regards to trusts, and then we're going to go on and talk about incapacity, and that way leave a little bit of time for questions and answers, because I know that we want to make sure we left a couple of minutes for that, is you'll see that, again, this depends on the state that you're in, but trusts might be used for something called Medicaid purposes. So I'm hoping no one on this workshop has a situation, but if someone gets to the point where they need to go into a nursing home and they can no longer afford to pay for the nursing home, there's something called Medicaid. It has different names in different states. The most common is Medicaid. Like in Massachusetts, it's actually called Mass Health, but it's Medicaid. And the idea behind Medicaid is, again, if someone can no longer pay for the long-term care, which again, you guys are doing proper planning, so this hopefully should not be an issue for you. But if someone hasn't done proper planning and they do go into a nursing home and can't pay anymore, they would try to go on something called Medicaid, which is a governmental benefit that pays for someone's long-term care in a skilled nursing level facility. So again, depending on the state, depending on how long someone has before they go into a nursing home, they might try to do a trust to help protect some assets from needing to be used for Medicaid purposes. And so that's a whole separate topic. Again, devil is in the details on it. So you don't want to just make that happen without really seriously sitting down and talking with someone about it. But there are irrevocable trusts that are used to provide asset protection. The most common that I see And the ones that we really try to do it for here in Massachusetts specifically is to try to make sure that, especially if someone is married, that the spouse who is not going into the nursing home does not get impoverished. And so it can be a very useful tool. All right. Again, a whole separate workshop. So with that, before I start talking about the documents for if you become sick or incapacitated, I want you to go back to your worksheet. And under item 4, it's going to ask you, 1, do you have a trust? So I want you to say A or B, yes or no. Then under that, I would like you, and this you might have to do after this workshop just because of timing, I want you to go to the second part of that, which says, are any of the following important to you? And those are going to touch on the ones that we just talked about. You know, is avoiding probate important to you? Keeping things private, minimizing taxes. So mark off those things that are important to you, because that will help you understand whether is a trust important to me or not. So knowing that, I am now going to shift and talk about an additional few documents that are crucial to have if you should ever become incapacitated. So knowing that, the first one I'm going to talk about is something called a financial power of attorney. So a financial power of attorney, what that does is it's a legal document which gives whoever you designate, the surrogate or agent, and depending on the state you're in, it might have different terms, but it's whoever's taking care of your financial stuff for you under the power of attorney, it allows them to step into your shoes. Now, you can have it where they can only have the power, even though you do the document now, you can have it where they only have the power if you're incapacitated. So it only triggers and becomes powerful then. It's called a springing or a power of attorney. Or it could be a power of attorney that's effective immediately upon you signing it. It just depends on your circumstance, and it depends on whether it makes sense to have someone have the power to do it now. The fact that someone has the power to do it doesn't mean that you too don't. It just means that they do. So normally we don't have it effective immediately unless it's really appropriate for the circumstances. But we definitely want to make sure there is a power of attorney, financial power of attorney. So that way, at the very least, if you're incapacitated, that person will have the legal authority to handle financial stuff for you. Now, the book will talk about limited power of attorneys and general power of attorneys. So I encourage you to definitely take a look at that to understand the difference between the two. But for regular estate planning, when we're doing that, it's normally a general financial power of attorney because we want that person to be able to do whatever you would have needed to do. But again, had you been able to do it, right? And so for that purpose, we normally want it general. And normally it's upon incapacity unless there's a reason for it to become effective immediately. Now, you may say, well, you know what? If I have a trust, why do I need a power of attorney? Now, if you don't have a trust, you really need a power of attorney. But even if you have a trust, you still need a power of attorney because a power of attorney is going to deal with anything that's in your name. So if it's in your name, even though it might have a beneficiary, which might be your trust, it's still in your name. So the only person legally authorized to handle something in your name is the financial power of attorney, agent, or surrogate. If it's owned by the trust, it's the trustee. So knowing that, everyone should have a financial power of attorney in place in case, especially if you should ever become incapacitated. Now, before I leave this, I want to talk about what happens when someone doesn't have a financial power of attorney. If someone doesn't have a financial power of attorney and someone needs to take care of financial stuff for someone, guess what happens? So that person that needs to take care of things for the person needs to go into the court system, into probate, to get legal authority to act on that person's behalf. It's called, at least in Massachusetts, it's called a conservator. Just like if upon passing, if things go through probate, it's time consuming, it's expensive, and boy, is it stressful. You can avoid that by making sure you have a power of attorney in place. So please, that is a crucial document that everyone needs to have. So on your worksheet assessment form, you will find under item 5, which I believe is on the last page, it will ask you, do you have a power of attorney, a financial power of attorney? So I want you marking off yes or no. Last set of documents for today. And then I'm hoping everyone can go and have an enjoyable lunch after we talk about any questions. The last set that I'm going to talk about are the health-related documents. The first one is called a healthcare directive. Now, again, depending on the state you're in, it could have different terms. It could be called an advance directive. It could be in Massachusetts, it's called a healthcare proxy. It has different terms. But the idea behind this is it's a legal document that, again, appoints someone, a surrogate or agent, who would have the ability to make medical decisions for you, but that would only trigger if you're unable to do so. So this is what the doctors look to, that if they can't talk to you, who are they legally authorized to talk to? So having this document is crucial so that you can say who that person should be. So if someone doesn't have that, depending on the state that they're in, someone may need to go into the court system and get appointed as something called a guardian. Again, time-consuming, expensive, really stressful. You can avoid that and not even worry about what your state says by doing a healthcare directive that says who has authority. And again, they're only going to have authority if you're not able to talk to the doctors. So there's a few additional documents, and these are actually all in the book that talk about additional health documents that support this one. One is called a living will. A living will is a declaration that says if I'm towards end of life, this is what this would be the, I wouldn't want extraordinary measures if nothing further can be done. That's different though from a DNR, a do not resuscitate order, or depending on the state that you're in, a MOLST or POLST being physician order for life-sustaining treatment, MOLST being a medical order for life-sustaining treatment. And those would talk more about what you would and wouldn't want. Those are very different. DNRs, MOLST, POLST are done with the doctor. The living will, which is an advance directive, it basically says, look, if the doctors have said can't do anything more, this is okay. It's okay not to do anything more. Again, the book goes much more into detail on it. And so because of timing and so on, I'm going to leave it for you to definitely take a look at the book. So with all that, oh, and by the way, on the worksheet, your final thing for that worksheet, under item number 6 at the very end, mark off whether you have a healthcare directive, yes or no. So knowing this, to kind of wrap this all up, estate planning, why is it so important? Because life is unpredictable. We want to get those documents done, whatever documents are appropriate for you, and are achieving whatever goal you are hoping to achieve, but get them in place and get them in place while you have capacity. Because if you don't have capacity, we can't do those kind of documents. So it's crucial that you get them done while you have the capacity. So I love giving homework. And then I will see if, Ryan, if there's any questions for anyone, but here's your homework over the next couple of weeks, because we're going to be meeting back in a few weeks from now. I'm going to have Ryan send you sometime this afternoon my answer key to this assessment for things I want you to watch based on how you answered your worksheet. But I also want you reading chapter 2 of my book, sections 2.1 through 2.6. That is going to go over everything that I just talked with you today about. So it's going to be a nice refresher and really help you be able to cement in those things that we talked about. If you haven't gotten your book yet, I'm sure it's on the way. You can just, picking on Ryan, so sorry, Ryan, if you're not the one, but I'm sure someone at Kendal will be able to help you with that. So with that, Ryan, any questions?
Yeah, with all that information, there are certainly questions to be had. First off, Tiffany, thank you so much for going through all that. It's a lot of information, a lot of helpful information though. So And as you said, you don't know what's ahead. So having everything in order is key. So for anyone who has any questions that they want to ask, please feel free to type those into the Q&A or chat. One person already asked a question there. Is there a difference in the way estate planning is done for a married couple versus non-married couples?
Yeah, there is. So there are a lot of commonalities. So, but that said, specifically for married couples, we're usually, again, looking at trying to minimize estate taxes, whether it's on the federal level or if there's a state level. So that will be very different as to how the trust will look. We might be also in the trust dealing with remarriage protection. If a spouse passes, how do we want to make sure that that surviving spouse is taken care of, but also guarantee that the assets will, upon their passing, go to where you want? So there are some differences, but otherwise it is generally kind of flows the same. Meaning that, like with a revocable trust, which is the foundation trust that everyone should have, it starts off saying that you're usually the trustee taking care of it, you're usually benefiting. It then kind of talks about who would take care of things when you can't, but that they're now taking care of it for you. So there's commonalities there. There'll be a lot of legalese that's the same. But that said, is probably more on the taxes, remarriage protection issues. That would be the differences.
Okay, very interesting. Trying to see if there's any other things here. One question that I had as you're discussing it, is there, whether it's misnomers or myths or stuff like that, what's something that you see someone thinking that they have something done, or they think that this is the way to go, and then they realize later down the road, or the family realizes after the fact, this was not the right way, or things that probably could have been avoided? What are some of those misnomers that you typically see?
Yeah, so no, thank you. So one being that a lot of people think that I have a will, so I'm good.
Mm-hmm.
And yes, or maybe no. Again, it depends on what their goals were. And so if their goals were what I listed on that assessment sheet, well, the will might not be doing that. So a lot of people think, oh, will's totally fine, it's going to cover it. Again, it really depends on what the person's goals are. I'd say another big myth for people is that, what? Estate planning, that's only for the very rich, right? It's for the Rockefellers, it's for the Vanderbilts. But no, estate planning is for everyone. It just depends on the complexity that will differ. So yeah, I mean, the Rockefellers, the Vanderbilts, I don't think any of them are on this Zoom, but that being the case, they have many, many different kind of trusts. Mm-hmm. But that said, trust, that is really can be for the regular normal person. It just, again, depends on what someone's goals are. And so many people think, oh, no, it just, my assets aren't there. You'd be surprised. Mm-hmm. You'd be surprised. And so it's crucial to sit down with an estate planning attorney.
Yeah, certainly that's something that I always heard growing up is, trust, like, oh, uber wealthy, stuff like that. Everyone just does a will, everyone does that. But as you're saying, like, it doesn't matter how much assets you have, what you're trying to do. It's all about the goals to it. And I would say too, as you're saying, like, it's where it's for everyone. It doesn't even matter, like, age too. I feel like some people like, oh, I'm young, I don't foresee anything happening. And it's easy to do that at certain ages. But I feel like comes a point where sometimes you've probably seen it, where someone's coming to you for the first time, and you probably would have done it 10 years ago if you were them. Is that?
Yeah, so I mean, we've definitely had it where I still remember this absolutely lovely couple. This was years ago. They were in their almost mid-90s at the time, and my office was actually on the second floor. And I can remember that they could come up the stairs faster than I could. So they were really spry. But they're like, yeah, we haven't done estate planning before. We figure it's time. Mm-hmm. And I was like, okay, well, glad you're getting it done. But bottom line is no matter what someone's age is, they
Mhm.
should be doing it. And even if they've done it,
Mhm.
and it's been 5+ years since they last did it, they should be looking at it being reviewed and updated.
Mhm.
But Ryan, just to kind of finish on that thought, is even when someone gets to age 18,
Yeah.
they're of legal age. Guess what, mom and dad? You no longer have legal authority to make health decisions or take care of finances for them. So we end up doing, I know as part of our practice here in Massachusetts, we get to see a lot of young adults, because they're adults now, going off to college, and we're getting powers of attorney, both for financial and medical, in place for them, because mom and dad don't have legal authority anymore. So even the 18-year-old should get something in place.
You kind of forget that as you hit that 18th birthday, it's all celebrations. You're finally an adult and everything there, but you forget there's legal changes to it. I mean, I kind of assumed that my parents would be the ones making decisions if something were to happen to me on it, but may not be the case from a legal standpoint on it all. Two questions just popped up here. Is Massachusetts considering was it raising $1 million estate tax? Like, are they thinking of changing that?
So there have been rumblings over the years on it being increased. I'm sure there's been rumblings about getting rid of it. There is nothing that's presently on the front burner about getting rid of it. So we are doing planning as if it's here to stay. Massachusetts is known as Taxachusetts. So we need those funds in order to keep our programs going, and it's got to come from somewhere. So could they get rid of it? They could, or they could increase it. But I know, at least for the Commonwealth, we need the assets. So I would be surprised if it changed anytime soon.
Okay. Next question here. So this individual, they've added transfer on death to all financial accounts, and they're in the process of doing that with their home as well, and investment accounts. Do they need a trust as well? If you have all those transfers on deaths in place, is a trust still necessary?
So excellent question. Well, all these have been great questions, but I love this question because devil's in the details. So yay, if you have a transfer on death called a TOD or a POD, which is called a pay on death, it is a beneficiary. So that means that upon your passing, it will go to the beneficiary. So yay, you've avoided probate. But now it comes down to what your goal is. If your goal is, okay, the person that is named as the beneficiary, one, maybe they're too young to receive, or maybe that beneficiary might be a situation where they really shouldn't just receive it outright. You better have a trust, because otherwise it's just going to them outright. And let's say that you get the kid who buys the Ferrari, or heaven forbid, you've got it going to an adult who is receiving governmental benefits for a special need they have, and now you've disturbed their benefits. Or they're a spendthrift, or they're going to go use it for really bad things. So yay for avoiding probate, but did you really accomplish the goal? And if it's like, oh, no, don't have any worry there, it can just go to them, well, perhaps it is okay, but devil's in the details.
It's good advice there. It's not just what you want. You also have to take into account the other person's situation too. Right. It goes back to the old no good deed goes unpunished thing. If they're working in some way and now you just disrupted everything that they were doing, could throw some wrinkles in there that were unexpected or potentially even unwelcomed, if that's what even though that's what you thought was the best intentions behind Correct. It. So and last question here, unless someone throws one else in the chat too. What are options for naming a person that can manage a revocable trust if the person for whom the trust is set up is incapacitated?
Can you read that one more time, Ryan?
Yeah. What are the options for naming a person that can manage a revocable trust if the person for whom the trust is set up is incapacitated?
So one of the things that, well, and I'm hoping this is going to answer this person's question, or at least give it the right direction. In the next workshop, we're going to talk about helpers, number one. So that was going to be a very important session to definitely be, if you can attend, make sure you listen to the recording. But that being the case, if you've got something, there should hopefully already in the document be that backup. But if you're saying, no, there is no one there, there should be some sort of default provision, whether it's in the power of attorney or in the trust, that would give a way for someone to get into the role. So I'm sorry to kind of hedge on that. So actually, I'm trying to see if I can take a look. Is it under the Q&A?
Yeah, it's in the Q&A.
Okay. Okay, so is it the one that says, so
it's the top one.
Okay.
Yeah, it's 1201.
Name for second manager. Yeah, so so John, to answer your question on that, it really, the trust is going to dictate who comes into the role. If there is no specific person listed, there should be a default provision that says how to get someone in, but it's going to all be based on what that particular trust says. So.
And John, and that's a great question too. As Tiffany said, next week, or not next week, 2 weeks from now, March 10th at 11 a.m. Is the second part in this series too, where we're going to be going over how to choose those helpers, how to choose that, and the process that goes, who to choose is another very important thing that sometimes gets overlooked on it. Another question here. Can a trustee be changed without having to go through an attorney to revise the trust completely? Can you kind of do it separate from an attorney?
Yeah, so again, and sorry to kind of bring it back to this, it's all going to be based on what that trust says. So if the trust says that my trustee is me, and if I can't take care of things, then it's Ryan, and if Ryan can't take things, then it's Susan, it's going to go according to that order. Now, in my trust, I may give someone or a group of people the power to say, remove Ryan and put in someone else, but it's all going to come down to what does the trust actually say.
And this individual is asking costs, like what does it financially, what does it look like for like a basic will, a trust, power of attorney, healthcare proxy? Obviously, it's probably going to differ based on attorney, firm, state, location, etc. Is there like a relative range that you usually will see for those very important documents?
Yeah, and this one I am going to be broad on because it's really going to differ, but I will give some thoughts I have on this. So one being, it will differ based on the state that you're in, because certain states like Massachusetts, a higher cost of living. So you might see higher costs than if someone was in a lower cost state, right? So there's that. So that being the case, the things I want to definitely mention is, please, no one on this, please don't do an online one without an attorney's support. Don't say, you know what, oh, I can just do this online. We've seen way too many bad things happen from it. So please don't do that. Even though, yes, is that the cheaper route? Sure. But that being the case, you're going to get junk. So knowing that, the thing that I would caution, and you are going to see, depending on your area that you're in, you will see a range. I would pay more attention to getting solid documents in place. Any specialist who specializes in estate planning should be able to do that. It's the additional services that are wrapped around, like, is the attorney helping with how things should be titled? Are they only doing the documents and saying good luck? Right? Are they not there to guide and help you and talk with you about the choices you're making? And they're just like, nope, fill in this form and we'll do it and done. So that's why I'm like, I can't say a price because it's comparing apples to oranges. I would caution that for whatever attorney you go to for your estate plan, you pick someone that's what they do. This is a true area of specialty. You don't want to go to someone that does a whole bunch of different areas of law because they're not a specialist in the area.
It's a great answer. And I think it goes back to too, as you say often, it depends on the situation, depends on the circumstances. I mean, someone might just be like, just give me the document, just get that done. But some people are wanting those additional services, those add-on features. They might want to go to an attorney where that's part of their package, where it's all inclusive to it all. Probably just depends on the situations. Reach out. I'm sure people shop for prices, and attorneys find the best fits. Tiffany's nodding her head. Yeah, that's so. Yeah, great.
Yeah, you just have to find out, what are your goals? What is the most important thing to you? And then go according to that. I mean, if price is the driver, well, then you're going to price shop. But if it's like, no, I want to make sure it's a competitive price, but I also want to make sure that this person is really part of my team going forward, well, there's going to be a bit of a premium to that, because it's not just the documents.
Well, Tiffany, thank you so much for joining us today. I'm not seeing any other questions pop up. And if you do have a question, we're going to be back here in 2 weeks doing the same thing next part in the workshop. Again, that will be on March 10th at 11 a.m. again, Eastern time. And we'll be going over how to choose your helpers, who to choose, and the best ways to go about that. This session, it has been recorded, and it will be posted to our Kendal at Home YouTube page. So you can feel free to go back if you were taking notes and you missed something, or you want to hear Tiffany go over it again and rehear everything word for word. Please feel free to go and do that. If you know of a friend or family member who you think might appreciate this information, please feel free to pass on that link to them. And we'd be more than happy to have them join for this next session here in 2 weeks. So Tiffany, again, thank you so much for your time. It was a wealth of information. And it's looking forward to seeing you again in 2 weeks here.
I'm looking forward to it. So thank you, everyone.